Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to take a look at the opinion in the Harvard case that struck down the affirmative action programs at Harvard and the University of North Carolina. And we're going to look at the principal opinion and Judge Thomas's concurrence. So stick around and hopefully this won't be too long, but hopefully it will be informative. So one of the things that you can do when you read a Supreme Court opinion is you can just read the syllabus. Now, the syllabus is not the opinion, and you can't cite the syllabus. It's prepared by the reporter of decisions, and it's not meant to be a part of the actual case. It's just there to help people understand the opinion. And the syllabus in this case is pretty spot on. It tracks the opinion very, very closely, and it's probably the easiest way to read and understand this case. But there are so many little birthday presents in this case, in the writing, that I really feel like we need to look at some of that in order to get a flavor of what's going on with this particular opinion. So I'm going to pull up the opinion and go through it as best we can and leave you with some thoughts about this particular case. Syllabus, and you can see that the syllabus runs, I think, for 7 pages or more before we actually get to the opinion. And the opinion does not bury the lead. It says Chief Justice Roberts delivered the opinion of the court. In these cases, we consider whether the admission systems used by Harvard College and the University of North Carolina, two of the oldest institutions of higher learning in the United States, are lawful under the Equal Protection Clause of the 14th Amendment. Spoiler alert, they're not. So it goes through the history of Harvard, and it says gaining admission to Harvard is no easy feat. It can depend on having excellent grades, glowing recommendation letters, or overcoming significant adversity. It can also depend on your race. So the admissions process works first by going to a first reader. In assigning the overall rating, first readers can and do take an applicant's race into account. Once the first read process is complete, there's an admissions subcommittee. The subcommittees can and do take an applicant's race into account when making their recommendations. And the third step is a full committee meeting, and again, at the beginning of the meeting, the committee discusses the relative breakdown of applicants by race. The goal, according to Harvard, is to make sure that Harvard does not have a dramatic drop-off in minority admissions from the prior class. At the end of the full committee, a racial composition of the pool of tentatively admitted students is disclosed to the committee. They then use that for what they call the LOP, and the LOP is where they winnow out the list of applicants on the basis of legacy status, recruited athlete status, financial aid eligibility, and race. In the Harvard admissions process, race is a determinative tip for a significant percentage of all admitted African American and Hispanic applicants. In other words, African American and Hispanic applicants get a preference that is denied to white and Asian applicants. And the students for fair admissions are primarily Asian applicants, are the ones behind that organization. So then we look at UNC, and again, readers are required to consider race and ethnicity as one factor in their review. During the years at issue in this litigation, underrepresented minority students were more likely to score highly on their personal ratings than their white Asian American peers, and were more likely to be rated lower by UNC readers on their academic program, academic performance, and extracurricular activities. And then after assessing their applicant materials, they formulated an opinion about whether the student should be offered admission. In making that decision, readers may offer a student a plus based on their race, which may be significant in an individual case. So if you are a member of a favored racial group, you might get a bump up. Following the first read process, applications go through a process called the school group review. And in making those decisions, the review committee may also consider the applicant's race. So we know that at these two schools, applicant race is a factor in the admissions. The question is not whether it is, the question is whether it should be. So let's look at that. Now, it's interesting because there are some bon mots dropped through the opinion in these footnotes that essentially attack the dissent in this case. And one of the things that it says is Justice Jackson attempts to minimize the role that race plays in UNC admissions by noting that the most academically excellent in-state black candidates had an admission rate of 97% versus 98% of Asian applicants. And the court says it's not clear how the rejection of just 2 black applicants over 5 years could be indicative of a genuinely holistic admissions process, as Justice Jackson contends. This is something that judges do in opinions. They take pot shots at the people who dissent, and the people in the dissent sometimes take rifle shots at the people who wrote the principal opinion. And I mean that allegorically, not factually. So the Supreme Court says we granted certiorari in the Harvard case and certiorari before judgment in the UNC case. Title VI provides that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied benefits of, or subjected to discrimination under any program or activity receiving federal financial assistance. We have explained that discrimination that violates equal protection of the 14th Amendment, committed by an institution that accepts federal funds, is also a violation of Title VI. Although Justice Gorsuch questions that proposition, no party asks us to reconsider it. We accordingly evaluate Harvard's admission program under the standards of equal protection itself. Before turning to merits, we must assure ourselves of jurisdiction. And essentially, the universities attacked Students for Fair Admissions as not being a legitimate or genuine group of that had standing for what's called organizational standing. And the Supreme Court goes through that a couple of pages and basically says, because Students for Fair Admissions complies with the standing requirements demanded of organizational plaintiffs, its obligations under Article 3 are satisfied. So it dispatched the standing issue there pretty much in the same way it dispatched the standing issue in the student loan case. And if you're thinking that I'm a little bothered by that, you're absolutely right. I believe standing should apply consistently and equally across the board, irrespective of what issue is before the court. In the wake of the Civil War, Congress proposed the states ratified the 14th Amendment, providing that no state shall deny to any person the equal protection of the laws. It's a foundational principle that absolute equality of all citizens of the United States politically and civilly before their own laws. The Constitution, they were determined, should not permit any distinctions of law based on race or color, because any law which operates on one man should operate equally on all. The 14th Amendment would hold over every American citizen without regard to color the protective shield of the law. And the court notes that as first the court embraced this aim of the Equal Protection Clause. What is this, we said, of the clause in 1880? But declaring that the law in the state shall be the same for the black as for the white, that all persons, whether colored or white, shall stand equal before the laws of the state. The broad and benign provisions of the 14th Amendment apply to all persons. Despite our early recognition of this broad sweep, the court quickly failed to live up to its core commitments. The court played its own role in that ignoble history in Plessy versus Ferguson. And in Plessy versus Ferguson, in the event you're not aware of that, it's the separate but equal case. Essentially, it determined that even though state universities in states like Missouri would not admit black applicants, because Missouri had a state school called Lincoln University that would admit black applicants, that was essentially a black college, well, because that it was separate and it was therefore equal by virtue of being separate. So the separate but equal doctrine came about as a result of that case. After Plessy, American courts labored with the doctrine of separate but equal for over half a century. There is an inherent folly in that approach, trying to derive equality from inequality, and that soon became apparent, according to the court. Even racial distinctions that were argued to have no palpable effect work to subordinate afflicted students. Separate cannot be equal, and the culmination of this approach came finally in Brown versus Board of Education, and that was the Supreme Court opinion that basically desegregated the schools, even though it happened in the 1950s and it took well to the end of the 1960s to actually get the schools desegregated. The conclusion reached by the Brown Court was thus unmistakably clear: the right to a public education must be available to all on equal terms. No state has any authority under the Equal Protection Clause to use race as a factor in affording educational opportunities. That's just the way it ought to be. In the decades that followed, this court continued to vindicate the Constitution's pledge of racial equality. Laws dividing parks and golf courses, neighborhoods and businesses, buses and trains, schools and juries were undone, all by a transformative promise stemming from our American ideal of fairness. The Constitution forbids discrimination by the general government or by the states against any citizen because of his race. The historical fact is the central premise of the 14th Amendment was to eliminate racial discrimination. Eliminating racial discrimination means eliminating all of it. An equal protection clause, we have accordingly held, applies without regard to any differences of race, of color, or of nationality. It is universal in its application. For the guarantee of equal protection cannot mean one thing when applied to one individual and something else when it's applied to a person of another color. And that is from the Regents of University of California versus Bakke. Bakke was an applicant to the University of California Medical School. Even though his grades and his scores were higher, he was consistently denied application when lesser qualified minority students were admitted ahead of him. And he sued, and it was a very fractured opinion. And essentially, in that case, they applied strict scrutiny, and the court said there are two compelling interests that permit resort to race-based government action. One is remediating specific identified instances of past discrimination, and two is avoiding imminent and serious risks to human safety in prisons, for example, such as a race riot. Our acceptance of race-based state action has been rare for a reason. Distinctions between citizens solely because of their ancestry are by their very nature odious to a free people whose institutions are founded upon the doctrine of equality. These cases involve whether a university may make admissions decisions that turn on an applicant's race. In a deeply splintered decision that produced 6 different opinions, none of which commanded a majority, we ultimately ruled in Bakke in favor of the school in part and in favor of Bakke in part. Judge Powell announced that he would eventually come to serve what would eventually come to serve as the touchstone for constitutional analysis of race-conscious admissions policies, finding 3 of the school's 4 justifications not sufficiently compelling, and the last interest asserted to be compelling, obtaining the educational benefits that flow from a racially diverse student body, was a constitutionally permissible goal. But a university's freedom was not unlimited. Racial and ethnic distinctions of any sort are inherently suspect, and neither still could it use race to foreclose an individual from all consideration simply because he was not the right color. The role of race had to be cabined. The Davis program therefore flatly contravened a core principle embedded in the Constitution and moral understanding of the times, the prohibition against racial discrimination. The court next took a look at a case called Grutter, and that was a case that also dealt with race-based admissions. And Grutter said that there were 2 dangers that race-based admissions were portending. The first is the risk that race will be used to develop into an illegitimate stereotype. Universities were thus not permitted to operate their admissions programs on the belief that minority students always or even consistently express some characteristic minority viewpoint on any issue. The second risk is that any race would not be used as a plus but as a negative to discriminate against those racial groups that were not the beneficiaries of race-based preference. A university's use of race, accordingly, could not occur in a manner that unduly harmed non-minority applicants. But even with these constraints in place, Grutter expressed marked discomfort with the use of race in college admissions. It observed that all racial classifications, however compelling their goals, were dangerous. To manage these concerns, Grutter imposed one final limit on race-based admissions. At some point, the court held, they must end. This requirement was critical, and it said all race-conscious admissions programs must have a termination point, they must have a reasonable durational limit, they must be limited in time, they must have sunset provisions, they must have logical endpoints, and there must be a deviation from the norm of equal treatment. It must be a temporary matter. The importance of the endpoint was not just a matter of repetition. Grutter thus concluded with the following caution. It has been 25 years since Justice Powell first approved the use of race to further an interest in student body diversity. We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. Well, flash forward, 20 years later, no end is in sight. Harvard's view about when race-based admissions will end doesn't have a date on it. Neither does the University of North Carolina's. Both insist the use of race in their admissions programs must continue. Respondents' admission systems, however, well-intentioned and implemented in good faith, fail each of the criteria. They must therefore be invalidated under the Equal Protection Clause of the 14th Amendment. Now from here, we're going to jump forward to Justice Thomas's concurrence. In looking at the concurrence, I'm going to discuss just a few passages, and I would recommend to anyone that you go to scotusblog.com and download the entire opinion and read it from the first page to the last, especially the dissents. I think what you'll find is that one group of these justices look at the history from a more recently focused view, and the dissenting justices look at it from a 1860 to 1960 point of view. And I think it is that historical focus of the two different groups that results in the differing, essentially the differing results here. But here's what Justice Thomas says. Our Constitution is colorblind and neither knows nor tolerates classes among its citizens. I wrote separately in Grutter, I meaning Justice Thomas, explaining that the use of race in higher education admissions, regardless of whether intended to help or hurt, violates the 14th Amendment. Because the court today applies genuine strict scrutiny to the race-conscious admissions policies and finds that they fail that searching review, I join the majority opinion in full. I write separately to offer an originalist defense of the colorblind Constitution, to explain further the flaws of the court's Grutter jurisprudence, to clarify that all forms of discrimination based on race, including so-called affirmative action, are prohibited under the Constitution, and to emphasize the pernicious effects of such discrimination. Substantial evidence suggests the 14th Amendment was passed to establish the broad constitutional principle of full and complete equality for all persons under the law, forbidding all legal distinctions based on race. This was Justice Harlan's view in his lone dissent in Plessy, where he observed that our Constitution is colorblind. And that's a theme that radiates through Justice Thomas's concurrence here. He goes through all of the history of the 14th Amendment. In the years before the 14th Amendment's adoption, jurists and legislators often connected citizenship with equality, where the absence or presence of one entailed the absence or presence of the other. The 13th Amendment freed the slaves, but the 14th Amendment was necessary in order to give those freed slaves any kind of freedom whatsoever, because the plain text of the 13th Amendment did not do that. It didn't grant them rights or grant them citizenship. So he goes through the entire history, not only of the Reconstruction period itself and all of the statutes that were passed that essentially tried to establish a colorblind society, but also the failed attempts at getting statutes passed. And finally, in what he calls the second founding, the 14th Amendment was drafted and ratified. The drafters and ratifiers of the 14th Amendment focused on this broad equality idea, offering surprisingly little explanation of which term was intended to accomplish which part of the amendment's overall goal. The available materials show, however, that there were widespread expressions of general understanding of the broad scope of the amendment, similar to that abundantly demonstrated in the congressional debates, namely that the first section of the amendment would establish the full constitutional right of all persons to equality before the law and would prohibit legal distinctions based on race or color. So he goes through all of these. He says there is some support in the history of enactment for at least 4 interpretations of the first section of the proposed amendment, and in particular of its privileges or immunities clause. It would authorize Congress to enforce privileges and immunities clause. It would forbid discrimination between citizens with respect to fundamental rights. It would establish a basic set of rights that all citizens must enjoy, and it would make the Bill of Rights applicable to the states. Notably, those 4 interpretations are all colorblind. He goes back to this theme again and again throughout his opinion. The Equal Protection Clause of the 14th Amendment assures protection for all equal citizens of the nation without regard to race. Put succinctly, our Constitution is colorblind. What Justice Thomas is saying in this concurring opinion is that whether you use race to elevate an African American admissions candidate or whether you use it to denigrate that African American candidate, either way, having any consideration of race is in fact discrimination. And that's true, because if you make race a criteria by which people are judged, you are inherently judging on race, which is racist, and it doesn't apply the Constitution in a colorblind manner. And this is a guy, Justice Thomas, who pulled himself up by the bootstraps, got himself a good education, got himself a good legal education, and became a Supreme Court justice, as an example to many African American lawyers who have followed in his footsteps. And so, at least from my point of view, it looks to me like he is saying the reason we have to get rid of affirmative action is because while it may be elevating African American students today, there is no guarantee that it won't be pulling them down in the future. Admission should be based on merit and merit alone, just as getting ahead in the real world is often based on merit, getting ahead, not on race, not on sex, not on gender, not on anything other than merit. And that's sort of the libertarians' view of how people should get ahead. Now, our society doesn't correspond to that, right? We have a long way to go in discrimination, and particularly in anti-discrimination laws. But I do think that this opinion is probably a good first step down that road. We should not be considering anybody's race in making decisions about them. As Martin Luther King said, we should judge on the content of their character, on the content of their behavior, and not on the color of their skin or their race or their religion or anything else. It should be a merit-based system. So that's the opinion. Again, I do not have time. It would take me an hour and a half to go through this opinion and do it complete justice. I pulled out the stuff that I thought was important and put it in this video. I hope you will forgive me if I've left out something you think should be in there. Again, read the opinion. You can get it off of the SCOTUS blog. You can download it and read it from cover to cover, and I would urge you to do that. Thank you so much for watching. I hope you have a marvelous day. And if you have the opportunity, please try to go out of your way and do something nice for someone. I'll be here later on, and you can catch me down here again shortly with another case. See you then. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.